this public interest litigation has played a pivotal role for cheap and accessible justice for the poor and indigent in India. Now, in this session, we are purely focusing on gender equality and gender justice. As we all know, friends, man and woman are two halves of humanity, and no one can claim the superiority over another gender. Neither can reach its highest creative excellence without the cooperation of the other. And also, through the ages, though a woman is placed on a pedestal, mother of mankind, and cruelties have been inflicted on her, often without reason and mostly without just cause. This is my introduction to this particular subject, wherein why the gender equality and gender justice is important for us. Before going to discuss the crux of the subject now in this hour, I would like to recall your attention to the President Trump's address to the nation in his inaugural presidential address. After taking oath, he spoke on several issues, and his thrust was purely on America first. And another important aspect was, in the United States of America, only two gender, that is man and woman. That is the sentiment of Republican Party. It is reflected there. And another disturbing trend is, in the United States of America, the president of USA signed an executive order restricting third gender from entering military forces. What we are discussing today, the gender in India, is man, woman, and also a third gender. Whether you like it or not, LGBTQ plus, the category what we talk, is considered as a third gender. They are also have their own right, entitled to their own rights. Keeping this in background, let us discuss how the men and women are treated in ancient India. They were treated equally. The equal position was also being enjoyed by women as that of a man in both spiritual and temporal matters. The best example is in the ancient period, the both men and women, they used to sit together for performing religious functions, religious work. Though we have entered new millennium, the status of women is not been improved to the expected level, mainly due to some traditional notions and prejudice towards them from past many years. It is not merely because the legislative insufficiency, it is because of societal attitude towards women. The contemporaneous legislations, if you take for that matter, I'm going to quickly bring it to your notice that how many international covenants or treaties are responsible for advocating the status of women. The equal rights of men and women is a global norm in spite of the discrimination continues. In India, we compare women and consider her as goddesses of learning, Saraswati, of wealth, Lakshmi, and of power, Durga or Parvati. Though we consider she is still treated as second-class citizen when it comes to reality. There are a number of international covenants and treaties which advocates for non-discrimination. The first and foremost is United Nations Charter 1945, and later which was declared in 1948 as UDHR, that is United Nations Universal Declaration of Human Rights, 1948, wherein we have advocated the equal rights for both men and women. Then in International Covenant on Civil and Political Rights in the year 1966, which guaranteed equality for both sexes. In 1966, again, the International Covenant on Economic, Social and Cultural Rights, which promises women equality of status. One more international convention that is called as CEDAW, CEDAW in 1981, that is the Convention on the Elimination of All Forms of Discrimination Against Women, which provides for women equal rights with those of men on equal terms. There shall not be any discrimination based on sex, and it is against to all forms of violence against women. The Fourth World Conference held at Beijing in 1995 reaffirmed again the gender equality as a fundamental prerequisite for social justice. It is a fundamental prerequisite for ensuring social justice. We have quickly gone through some important international conventions. India is also influenced by these treaties, and framers of Indian Constitution, they meticulously used some terminologies in the Constitution to ensure justice, gender justice, and gender equality. It is clear from the first word in the Constitution in preamble that we the people of India, the word used is we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. When we use the term we the people of India, it also includes both men and women. Further, the preamble in the Constitution says that ensure justice, social, political, and economic, it is inclusive of both the sexes, that is men and women. ನಾವು ಭಾರತದ ಸಂವಿಧಾನದ ಮಹತ್ವಪೂರ್ಣ ಪೀಠಿಕೆಯಲ್ಲಿ ಮೊದಲನೇ ಪದ ಭಾರತೀಯರಾದ ಪ್ರಜೆಗಳು ಅಂತ ನಾವೇನು ಹೇಳ್ತೀವೋ ಅಲ್ಲಿ ಹೆಣ್ಣು ಮಕ್ಕಳು ಮತ್ತೆ ಗಂಡಸರು ಇಬ್ಬರಿಗೂ ಸಮಾನವಾದಂತ ಅವಕಾಶ ಇರೋದನ್ನ ನಾವು ನೋಡ್ತಾ ಇದೀವಿ. ಹಾಗೇನೆ ಸಾಮಾಜಿಕ, ರಾಜಕೀಯ ಹಾಗೂ ಆರ್ಥಿಕ ನ್ಯಾಯ ಅಂತ ಹೇಳುವಾಗ ಅದರಲ್ಲಿ ಇಬ್ಬರಿಗೂ ಕೂಡ ಸಮಾನವಾದಂತ ನ್ಯಾಯನ ಕೊಡಬೇಕು ಅಂತ ಅನ್ನೋದೇ ನಮ್ಮ ಸಂವಿಧಾನದ ಕರ್ತೃಗಳ ಉದ್ದೇಶ. ಅಂಡ್ ಆಲ್ಸೋ ಟ್ರೀಟ್ everyone equally includes both men and women. But I'm going to impress upon you one important aspect, friends. Being a lawyer, if I say that right to equality is fundamental right in absolute form, that's wrong, because I am not subscribed to that idea. Treating equals equally is good. Treating unequals equally is also amounting to practice inequality. Please take it from me. I quote, treating equals equal is encouraging, but treating unequals equal is also amounting to practicing of inequality. ಇಷ್ಟೇ ನಾನು ಹೇಳಿದ್ದು. ಒಂದೇ ಸಂದರ್ಭದಲ್ಲಿ ಸಮಾನವಾಗಿರ್ತಕ್ಕಂಥ ಇಬ್ಬರ ಮಧ್ಯೆ ಸಮಾನವಾಗಿ ಕಾನೂನಿನನ್ನ ಅನ್ವಯಿಸಿದ್ರೆ ಸರಿ. ಆದ್ರೆ ಇಬ್ರು ಅಸಮಾನರಿದ್ರೆ ಅಂತವ್ರ ಮಧ್ಯೆ ಒಂದೇ ರೀತಿಯಾದಂತ ಸಮಾನತೆನ ತರಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಕೂಡ ಅಸಮಾನತೆಗೆ ಕಾರಣ ಆಗುತ್ತೆ. ಹೇಗೆ? ಎ ಸುಮೋ ರೆಸ್ಲರ್ ಇಸ್ ದೇರ್ ಅಂಡ್ ಆಲ್ಸೋ ಎ ಫೀಬಲ್ ಪರ್ಸನ್. ಒಬ್ಬ ನರ್ಪೇತ್ಲ ನಾರಾಯಣನ್ನು ಜಪಾನಿಂದ ಬಂದಿರೋ ಸುಮೋ ರೆಸ್ಲರ್ನು ಬಿಟ್ರೆ ಜಗಳ ಇದು ಫೈಟ್ ಮಾಡ್ರಪ್ಪ ಅಂದ್ರೆ ಸರಿ ಹೋಗುತ್ತಾ ಅದು? ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ, ಲಾ ಶುಡ್ ಬಿ ಈಕ್ವಲ್ ಅಮಾಂಗ್ ಈಕ್ವಲ್ಸ್, ನಾಟ್ ಅಮಾಂಗ್ ಅನ್ಈಕ್ವಲ್ಸ್. You cannot treat me with Tata, Birla, or Reliance people. They are something different. Correct? Hagagi, what in the preamble, what we ensure is this. We, the people of India, committed for social, political, and economic justice for everybody, including women. And we have some of the fundamental rights and directive principles of state policies which says that there shall not be discrimination based on religion, race, caste, sex, and place of birth, etc. That I am going to discuss little later with the help of case laws. Then friends, even though all these rights are there specifically in the Indian Constitution, some of the fundamental rights ensures equality, that is Article 14, which confers both men and women equal rights and opportunities in political, economic, and social spheres. And Article 15, more particularly applicable to women, which prohibits discrimination against any citizen only on grounds of religion, race, caste, sex, and place of birth, etc. ಪ್ರಮುಖವಾಗಿ ಸಂವಿಧಾನದ 15ನೇ ಅಲ್ಲಿ ನಮಗೆ ಈ ಒಂದು ಅಂಶವನ್ನು ನಾವು ಗಮನ ಇಡಬೇಕಾಗತ್ತೆ. ಅದೇನಂತಂದ್ರೆ ಸಂವಿಧಾನದ 15ನೇ ವಿಧಿನಲ್ಲಿ ಧರ್ಮ, ಜಾತಿ ಹಾಗೂ ಲಿಂಗಗಳ ಆಧಾರದ ಮೇಲೆ, ವರ್ಣ ಲಿಂಗಗಳ ಆಧಾರದ ಮೇಲೆ ತಾರತಮ್ಯ ಮಾಡುವಂತಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಸಂವಿಧಾನದ 15(3) ವಿಧಿನಲ್ಲಿ ಅನುಚ್ಛೇದದಲ್ಲೇ ಪುನಃ ಹೇಳ್ತಾರೆ, ಅದರಲ್ಲಿ ದೇರ್ ಇಸ್ ಅ ಸ್ಪೆಷಲ್ ಪ್ರಿವಿಲೇಜ್ ಫಾರ್ ವಿಮೆನ್ ಅಂಡ್ ಚಿಲ್ಡ್ರನ್ ದಟ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಕಸ್ ಲಿಟ್ಲ್ ಲೇಟರ್. Article 16, which provides for equality of opportunities in public employment. You are all recruited without any discrimination now, correct? Based on your merit you have chosen. You are not discriminated. You are not being discriminated based on you are a lady or something. Some of you may be recruited under rural woman quota. Something is there. ಅದು ಇದೆಯಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ಅದಕ್ಕೆ ಪ್ರೊಟೆಕ್ಷನ್ ಅಂತ ನೀವು ಕೇಳಿದ್ರೆ ನಾನು ಹೇಳ್ತೀನಿ ಈಗ ನೆಕ್ಸ್ಟ್ ಬರೋವಾಗ. ನೆಕ್ಸ್ಟ್ ಆರ್ಟಿಕಲ್ 39A, ವಾಟ್ ಇಟ್ ಸೇಸ್ ಇಸ್ ದಟ್ ಸ್ಟೇಟ್ ಶಲ್ ಡೈರೆಕ್ಟ್ ಇಟ್ಸ್ ಪಾಲಿಸಿ ಟುವರ್ಡ್ಸ್ securing all its citizens, men and women, equally the right to means of livelihood. Means of livelihood, ಜೀವನೋಪಾಯದ ಮಾರ್ಗಗಳು ಅಂತ ನಾವೇನ್ ಕರಿತೀವಿ. The means of livelihood has to be shared equally among men and women, that cannot be discriminated ಅಂತ ಹೇಳುತ್ತೆ. Article 39, class C, which ensures that equal pay for equal work. Equal pay for equal work. You are all recruited as lecturers. Your counterpart, lady teachers cannot be denied UGC pay scale, and only men are preferred to get UGC scale and others are getting only state scale or something. State cannot make such a policy because equal pay for equal work, as declared by the Supreme Court on several occasions as a fundamental right. There shall not be any discrimination based on sex, caste, religion, race, etc. Article 42, which says there shall not be just and humane conditions of work and maternity relief for women. Though it is not a fundamental right, it comes under directive principles of state policy. There is a clear provision there. State has to make special provision for women to provide her humane working condition and maternity relief. That's why we have maternity relief act or something we have where the woman can claim special leave during her prior to her pregnancy, during her pregnancy, even after delivery, as a lactating mother to take care of the baby. ಬಾಣಂತಿಯರು ಅಂತ ನಾವೇನ್ ಕರಿತೀವಿ, ಅದಕ್ಕೆ ಮೆಟರ್ನಿಟಿ ಲೀವ್ ಅಲ್ಲಿ ಪ್ರಾವಿಷನ್ ಇರೋದು ನಾವು ನೋಡಬಹುದು. Very important is we are always concentrating on fundamental rights. There are some fundamental duties also. What fundamental duty? That is Article 51, capital A, class E. What it says is that it is the duty of every citizen to renounce the practices of derogatory to the dignity of woman, which means no one can indulge in any of the activities which can denigrating the status of woman. ಯಾವುದೇ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಮಹಿಳೆಯರ ಘನತೆಗೆ ಗೌರವಕ್ಕೆ ಚ್ಯುತಿ ಬಾರದಂತೆ ನಡೆದುಕೊಳ್ಳತಕ್ಕಂಥದ್ದು ಸಹ ಒಂದು ಮೂಲಭೂತ ಕರ್ತವ್ಯ ಅಂತ ಹೇಳಿರೋದನ್ನ ನಾವು ನೋಡಬಹುದು. ಮತ್ತೆ ಆರ್ಟಿಕಲ್ 325 which says that there must be a common electoral roll. There shall not be any discrimination on religion, race, caste or sex. ನಮ್ಮೆಲ್ಲರಿಗೂ ಯೂನಿವರ್ಸಲ್ ಫ್ರಾಂಚೈಸ್ ಸಿಸ್ಟಮ್ ಆರ್ ಯೂನಿವರ್ಸಲ್ ವೋಟಿಂಗ್ ಸಿಸ್ಟಮ್ ವಾಟ್ ವಿ ಕಾಲ್, wherein a woman cannot be denied the voting right. You remember, it is not Article 14, it is not Article 14, Article 15 or Article 16 which provides the reservation. In fact, Article 325 which brings in absolute equality among men and women, because there shall not be any discrimination. You remember, in England, they fought for many years women to get right to vote. In 1947, they were recognized. Very recently, Saudi Arabia recognized women to vote. Even in England, till 1947, they claimed themselves that they are the champions of human rights. But they provided voting rights to women in the year 1947. But in India, in the constitution itself, in a single stroke, the framers of our Indian constitution gave voting right, whether you are a poor or rich, whether you are a woman or men, equal right. One vote, one right. One value. One vote, one value. That is the equality we brought in. Then adult suffrage, Article 326, as we have already discussed. Then friends, why do we need this type of special provisions for women? Because Article 15 of the Indian Constitution, which says that, before that Article 14 says that there shall be equality before law and equal protection of laws. Article 15 says that there shall not be any discrimination based on sex, caste, religion, race or place of birth, etc. But Article 15 clause 3 says that the state can make special provision for the betterment of women and children. ನೋಡಿ, ಆರ್ಟಿಕಲ್ 15 ಅಲ್ಲಿ ಯಾವುದೇ ತಾರತಮ್ಯ ಮಾಡುವಂತಿಲ್ಲ ಅಂತಾರೆ. ಆದ್ರೆ 15 ಕ್ಲಾಸ್ 3 ನಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಮಹಿಳೆಯರು ಮತ್ತು ಮಕ್ಕಳ ಅಭಿವೃದ್ಧಿಗಾಗಿ, ಅವರ ಒಳಿತಿಗಾಗಿ ವಿಶೇಷವಾದ ಸೌಲಭ್ಯವನ್ನ ಕೊಡಬಹುದು ಅಂತ ಹೇಳ್ತಾರೆ. ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಹ್ಯಾವ್ ಸಮ್ ಕೇಸ್ ಲಾಸ್. Very, very interesting case. Why do women require special treatment? In Munn versus Illinois, one important case, Muller versus Oregon, Muller versus Oregon, one important case wherein American Supreme Court held that it is the society's interest in protecting the vigor of woman, the muscular wing. This is the responsibility of the state. The woman is considered as a weaker sex or vulnerable. Then it is the collective responsibility of the society to protect her. Keeping that in mind, our framers of the Indian Constitution, they made a special provision under 15 clause 4 that the state can make special provision for the betterment of women and children. Exercising that power, the states are having this provision. Article 15 is called as protective discrimination. 15 clause 3 is called as protective discrimination. Yes, we do. We are practicing inequality. We are discriminating, but we are discriminating it is because we are protecting vulnerable section. Who are the vulnerable section? Women and children. ಅದಕ್ಕೆ ನಾವು ಅದಕ್ಕೆ ಪ್ರೊಟೆಕ್ಟಿವ್ ಡಿಸ್ಕ್ರಿಮಿನೇಷನ್, ಕನ್ನಡದಲ್ಲಿ ರಕ್ಷಣಾತ್ಮಕ ತಾರತಮ್ಯ ಅಂತ ಕರಿತೀವಿ. ನಿಜ, ನಾವು ತಾರತಮ್ಯ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಆದ್ರೆ ರಕ್ಷಣೆಗೋಸ್ಕರ ತಾರತಮ್ಯವನ್ನ ಮಾಡ್ತಾ ಇರ್ತಕ್ಕಂಥದ್ದು. There are some affirmative action initiated by the state in bringing gender equality under the Constitution. In one case, that is Rajesh Kumar Gupta versus State of UP, the state government reserved 50% of the post in favor of women candidates in some employment. Then the Supreme Court held that it is not arbitrary, it is not a discrimination, because for some post the woman is more suitable. ಈಗ ನೀವೆಲ್ಲರೂ ಲೆಕ್ಚರರ್ ಆಗಿ ಸೆಲೆಕ್ಟ್ ಆಗಿದ್ದೀರಾ. ನಿಮ್ಗಳಲ್ಲಿ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಹೆಣ್ಮಕ್ಳನ್ನ ಬಿಟ್ಟು ನಿಮ್ಮನ್ನೇನಾದ್ರೂ ತಗೊಂಡೋಗಿ LKG ಮಕ್ಳಿಗೋ ಸ್ಕೂಲ್ ಮಕ್ಳಿಗೋ ಟೀಚ್ ಮಾಡಿ ಅಂತ ಬಿಟ್ರೆ, ಆ ಮಕ್ಕಳೆಲ್ಲ ನಮ್ಮಲ್ಲಿ ಫುಟ್ಬಾಲ್ ಆಡ್ದಂಗೆ ಆಡ್ಬಿಡ್ತೀವಿ ನಾವು. ನಮ್ಗೆ ಆಗೋದಿಲ್ಲ, ತಡ್ಕೊಳಕ್ ಆಗೋದಿಲ್ಲ. ಓನ್ಲಿ ವುಮನ್ ಈಸ್ ಮೋರ್ ಸೂಟೆಡ್ ಟು ಟೇಕ್ ಕೇರ್ ಆಫ್ such kind of children. Correct? You agree? Then reserving maximum number of posts in favor of women is not discriminatory. It is the state policy. The state can make the, provide the maximum opportunity to women to serve in such sector. ನಾನು ತಮಾಷೆಗೆ ಹೇಳ್ತಾ ಇರ್ತೀನಿ ನಮ್ಮ ಹುಡುಗರುಗಳಿಗೆ, ಕೇಳಿಸ್ಕೊತಾ ಇದ್ದೀರಲ್ವ ಎಲ್ಲರೂ? ಕೇಳಿಸ್ಕೊತಾ ಇದ್ದೀರಿ ಅಂತ ಹೇಳ್ತೀನಿ.
ಹೌದು ಸರ್,
ಸರ್ ನಮ್ಗೆ ಯಾವ್ಯಾವ ಕಾಲ್ ಬರ್ತವೆ. ನಿಮ್ಗೆ ಲೋನ್ ಬೇಕಾ, ಅಥವಾ ನಿಮ್ಗೆ ಎಲ್ಲಾದ್ರೂ ಸೈಟ್ ತಗತ್ತೀರಾ ಅಲ್ವಾ? ಆ ಕಡೆಯಿಂದ ಯಾವನಾದ್ರೂ ಒಬ್ಬ ಗಂಡಸು ಫೋನ್ ಮಾಡ್ಲಿ ನೋಡೋಣ, ಕರ್ಕಶವಾಗಿ ಬೈದಿಟ್ಬಿಡ್ತೀವಿ, ಇಡೋ ಮಗನೇ ಅಂತ ಬೈದಿಟ್ಬಿಡ್ತೀವಿ. ಅದೇ ಆ ಕಡೆಯಿಂದ ಒಂದು ಮೆಲೋಡಿ ವಾಯ್ಸ್ ಬಂದ್ರೆ, ಒಂದು ಹೆಣ್ಮಗು ಫೋನ್ ಮಾಡಿದ್ರೆ, ನಿಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇರ್ಲಿ ಇಲ್ಲದೆ ಇರ್ಲಿ ಸುಮ್ಮನೆನಾರು ಕೇಳಿಸ್ಕೋತೀರಿ. ಹೌದಾ, ಎಷ್ಟು % ಇಂಟ್ರೆಸ್ಟು, ಏನ್ ಗ್ಯಾರಂಟಿ ಕೊಡಬೇಕು, ಸುಮ್ಮನೆ ಕೇಳಿಸ್ಕೊತೀರಿ. ಹಾಗಾಗಿ ಶಿ ಇಸ್ ಬೆಟರ್ ಸೂಟೆಡ್ ಟು ಸಚ್ ಪೋಸ್ಟ್. ಕರೆಕ್ಟಾ? ರಿಸೆಪ್ಷನಿಸ್ಟ್ ಆದ್ರೆ ಮತ್ತೆ ಈ ತರದಕ್ಕೆಲ್ಲ ಕಾಲ್ ಸೆಂಟ್ರಲ್ಲಿ ಕೆಲಸ ಮಾಡೋಕೆ ದೇ ಆರ್ ಮೋಸ್ಟ್ ಸೂಟೆಡ್. ಹಾಗಾಗಿ ಇಫ್ ಯು ಪ್ರೊವೈಡ್ ರಿಸರ್ವೇಶನ್ ಇನ್ ಸಚ್ ಸೆಕ್ಟರ್, it is not violative of right to equality as held by the Supreme Court. And in another case, Supreme Court held that even providing 100% reservation in some sector, it is not violative, it is right. It is the policy decision of the state can take. In one case, what has happened, one boy, he filed a public interest litigation before the Supreme Court, stating that opening of separate women's school and women's college is violative of Article 14 of the Constitution. ಹೆಣ್ಮಕ್ಳಿಗೆ ಯಾಕೆ ಸಪರೇಟ್ ಆಗಿ ನೀವು ಕಾಲೇಜ್ ಓಪನ್ ಮಾಡಬೇಕು? ಮಹಾರಾಣಿಸ್ ಕಾಲೇಜಲ್ಲಿ ಯಾಕೆ ಬರೀ ಹೆಣ್ಮಕ್ಳೇ ಹೋಗ್ಬೇಕು, ಗಂಡು ಮಕ್ಳಿಗೂ ಅಡ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ಇವನು. ಸರಿ, ಆವಾಗ ವಾಟ್ ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ ದಟ್ ದಿ ಸ್ಟೇಟ್ ಕ್ಯಾನ್ ಮೇಕ್ such a provision because you see why we always admire the Mysore Maharaja and their contribution is this. they for the first time opened a special school for women. ಅಲ್ಲ, ಹೆಣ್ಮಕ್ಳಿಗೆ ಸಪರೇಟ್ ಸ್ಕೂಲ್ ಶುರು ಮಾಡಿದ್ರು, ಹೆಣ್ಮಕ್ಳಿಗೆ ಸಪರೇಟ್ ಕಾಲೇಜ್, ಹೆಣ್ಮಕ್ಳು ಸ್ಕೂಲು ಕಾಲೇಜಿಗೆ ಸೇರ್ಕಳದೇ ಇರೋ ಸಂದರ್ಭದಲ್ಲಿ ಸಪರೇಟ್ ಆಗಿ ಅವ್ರಿಗೆ ಎಜುಕೇಶನ್ ಕೊಡೋದಿದೆಯಲ್ಲ, ಇಟ್ಸ್ ಎ ಗ್ರೇಟ್ ಅಂಡ್ ನಾವೆಲ್ ಐಡಿಯಾ ಅಂಡ್ ದೇರ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ immense to the field of education. We have to hats up to such people. ಹಾಗೆ ಆ ತರ, in case if you open up a special college for women exclusively, it is not violative of Article 14 or 16 as said by the Supreme Court in good number of cases. As I've already mentioned, that Muller versus Oregon case decided by American Supreme Court, what they observed is this: why do women needs special provision for her betterment? For which American Supreme Court has an answer. Answer is this: special provision can be made in the light of woman's physical structure and the performance of maternal functions in order to preserve the strength and vigor of the race. I would like to read again. The observation by the American Supreme Court is this: woman's physical structure and the performance of maternal functions in order to preserve the strength and vigor of the race, they need special provisions. Because the woman is blessed as well as cursed. She is blessed because she can effectively participate in reproductive activities. She can give birth to a baby, nurture a baby, she can mold him. And at the same time, she is cursed because she is undergoing many physical changes based on what you call the nature blessed or cursed or whatever it may be. In such circumstances, providing her some special relief is not violative of right to equality. Hence, to achieve gender equality, some special provisions must be necessary to protect her. And also to protect her from some cruel practices like Devadasi system, that is naked parade, that is Bettale Seve. Some other practices are there, Sati practice, for example. Then we need to protect her from all such practices in the society. One important case was decided in the year 1954 by the Supreme Court regarding section 497 of Indian Penal Code. Now Indian Penal Code is replaced by BNS, that is Bharatiya Nyaya Samhita. What 497 was dealing with adultery. Adultery means that is Paradhara Agaman or something we call. What offense was there is this. You see, this was questioned by one person before the Supreme Court stating that it is violative of right to equality. What section 497 dealing was this: a man having sexual intercourse with a woman, knowingly that she is the wife of another, knowingly that she is not his own wife, then he is liable for punishment. You see, once again, I tell you, if a man has a sexual intercourse with a woman, knowingly that she is not his own wife, or knowingly that she is the wife of another, which means a married woman, you remember, married woman, then he is said to be committed the offense of adultery, and that woman is not liable for prosecution. ಇಲ್ಲಿ ಏನಾಗಿದೆ ನೋಡಿ, ಒಬ್ಬ ಗಂಡಸು ಬೇರೊಬ್ಬ ವ್ಯಕ್ತಿಯ ಹೆಂಡತಿಯ ಜೊತೆ, ಆಕೆ ತನ್ನ ಹೆಂಡತಿ ಅಲ್ಲ ಅಂತ ಗೊತ್ತಿದ್ದು, ಆತ ಬೇರೊಬ್ಬನ ಹೆಂಡತಿ ಅಂತ ಗೊತ್ತಿದ್ದು ಆಕೆ ಜೊತೆ ಲೈಂಗಿಕ ಸಂಪರ್ಕವನ್ನು ಹೊಂದಿದ್ರೆ ಗಂಡಸಿಗೆ ಮಾತ್ರ ಪನಿಷ್ಮೆಂಟ್ ಇರುತ್ತೆ, ಆ ಹೆಂಗಸಿಗೆ ಪನಿಷ್ಮೆಂಟ್ ಇಲ್ಲ. ಈ ಒಂದು ಶಿ ಇಸ್ ಎ ಪಾರ್ಟಿ ಟು ದ ಕ್ರೈಮ್, ಶಿ ಕ್ಯಾನಾಟ್ ಬಿ ಪ್ರಾಸಿಕ್ಯೂಟೆಡ್ ಅಂಡ್ ಪನಿಷ್ಡ್ as per section 497 of the Indian Penal Code. He questioned it before the court of law, stating that in most of the circumstances, even a woman also may be an equally contributing factor. She may also be responsible. Sometimes she may challenge a man. Sometimes she incite a man, encourage a man, instigate a man. Then in such circumstances, can she not equally responsible? How can you leave that? Even FIR cannot be filed against her. Her name cannot be mentioned in the FIR itself. ಅಲ್ಲಿ ಅಡಲ್ಟ್ರಿನಲ್ಲಿ ಏನಾದ್ರು ಆದ್ರೆ ಗಂಡಸಿಗೆ ಮಾತ್ರ ಶಿಕ್ಷೆ ಇದೆ, ಹೆಂಗಸಿಗೆ ಶಿಕ್ಷೆ ಇಲ್ಲ. ಇದನ್ನ ಪ್ರಶ್ನೆ ಮಾಡಿದ್ರೆ the court held that yes, it is a social legislation. The act is very much valid and constitutional because it is a social legislation. You've taken into consideration the stigma attached to that particular lady throughout her life. That is, it is like a permanent scar in her life in case if she brought before court of law and prosecuted before court of law. This was the opinion expressed by the Supreme Court in that particular case. But now Section 497 of Indian Penal Code has been declared as unconstitutional by the Supreme Court. Now there is no provision of adultery in statute book, but in BNS we have a provision. That provision is in consonance with Supreme Court decision. In Joseph Shine versus Union of India in the year 2018, in Joseph Shine versus Union of India, Supreme Court declared Section 497 of Indian Penal Code as unconstitutional because you see what it says. If you have a sexual intercourse with a married woman, is an offense. If you have a sexual intercourse with an unmarried woman, if you have a sexual intercourse with a widow, you are not liable for punishment. ಅರ್ಥ ಆಯ್ತಲ್ಲ? ಈಗ ನಿಮಗೆ ನೀವು ಯಾವಾಗ ಪನಿಷ್ಮೆಂಟು, ನೀವು ಮದುವೆಯಾಗಿರೋ ಇನ್ನೊಬ್ಬ ಹೆಂಡತಿ ಜೊತೆಗೆ ಇನ್ನೊಂದು ಅಂಶ ನಾನು ಹೇಳಿಲ್ಲ 497 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ, ವಿತೌಟ್ ಕನ್ನಿವೆನ್ಸ್, ವಿತೌಟ್ ಕನ್ಸೆಂಟ್ ಆರ್ ಕನ್ನಿವೆನ್ಸ್ ಆಫ್ ಅವರ್ ಹಸ್ಬೆಂಡ್. If you have a sexual intercourse with a woman with a consent or connivance of her husband, it is not an offense. If you have intercourse without the consent of her husband or connivance of her husband, connivance andre yes, impliedly given consent anta ಆತರ ನೋಡಿದ್ರು ನೋಡದೆ ಇರೋದು ಈ ತರದೇನ ಹೇಳ್ತೀವಲ್ಲ ನಾವು, ಅದು ಇಟ್ ಇಸ್ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂಡ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ದ ಕೇಸ್. ಹಾಗೆ ಇಲ್ಲಿ in Joseph Shine case, Supreme Court declared Section 497 as unconstitutional, stating that it is violative of Article 14, Article 21 of the Constitution. Why? Because if the husband permits his wife to have sexual intercourse with a third person, it is not an offense of adultery, isn't it? In case if he is not consented, then it becomes adultery, which means what? Even today under law, you are considered woman is an object. Woman is an object. She is always under the clutches of her husband. That impression that gives, correct? ಈಗ ಗಂಡನ ಅನುಮತಿ ಇದ್ರೆ ಅದು ಅಡಲ್ಟ್ರಿ ಆಗಲ್ವಂತೆ. ಗಂಡನ ಒಪ್ಪಿಗೆ ಇಲ್ಲದಿದ್ರೆ ಆತ ಇಂಡೈರೆಕ್ಟ್ ಆಗಿ ಒಪ್ಪಿಗೆ ಕೊಡದೆ ಹೋದ್ರೆ ಅದು ಅಂತಂದ್ರೆ ಅದರ ಅರ್ಥ ಏನು ಅಂದ್ರೆ, ಈವನ್ ಟುಡೇ ಯು ಟ್ರೀಟ್ ಯುವರ್ ವೈಫ್ ಆಸ್ ಎ ಚಾಟಲ್. Hence, the Supreme Court declared Section 497 of Indian Penal Code as unconstitutional in that particular case. That these are all the case laws and the developments which brought in gender justice and gender equality through judicial pronouncements. That's why we lawyers always use the judiciary as active judiciary. Sometimes we call judicial activism. ಕನ್ನಡದಲ್ಲಿ ನಾವು ಅದಕ್ಕೆ ಕ್ರಿಯಾಶೀಲ ನ್ಯಾಯಾಂಗ ಮತ್ತು ನ್ಯಾಯಾಂಗದ ಕ್ರಿಯಾಶೀಲತೆ ಅಂತ ಕರಿತೀವಿ. A law is not a stagnant. What the law made a centuries ago may not be relevant today. A law made a year ago may not be relevant today. ಹಿಂದೆ ಮಾಡಿರೋ ಯಾವುದೋ ಕಾನೂನು ಇವತ್ತು ನಮಗೆ ಸೂಕ್ತ ಅಂತ ಅನಿಸದೇ ಇರಬಹುದು. ಆ ಸೂಕ್ತ ಅಂತ ಅನಿಸದೇ ಇರುವಂತ ಕಾನೂನನ್ನೇ ನಾವು ಅದನ್ನ ಇಟ್ಕೊಂಡು ಅದ್ರ ಕೆಳಗಡೆ ಶಿಕ್ಷೆ ಕೊಡ್ತಾ ಹೋದ್ರೆ ಅದು ಏನಂತಂದ್ರೆ, ನಾವು ಅದನ್ನ ಬದಲಾದ ಸನ್ನಿವೇಶಕ್ಕೆ ತಕ್ಕಂತೆ ಕಾನೂನನ್ನ ಅಳವಡಿಸ್ಕೊಳ್ಬೇಕು. ಆ ಕೆಲಸವನ್ನ ನಮ್ಮ ಜುಡಿಷಿಯರಿ ಮಾಡ್ತಾ ಇದೆ. ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಅಂತ ಕರಿತೀವಲ್ಲ, ಅರ್ಥ ವಿವರಣೆ ಕೊಡ್ತಕ್ಕಂಥ ಕೆಲಸವನ್ನ ಜುಡಿಷಿಯರಿ ಮಾಡ್ತಾ ಇದೆ. ನಾನು ಇನ್ನೊಂದು ಪ್ರಕರಣ ಹೇಳ್ತೀನಿ ನಿಮ್ಗೆ, ಯಾಕೆ ಅಂತಂದ್ರೆ ಇದು ಗೊತ್ತು, ನಾನು ಆಗ್ಲೇ ಹೇಳಿದ್ದೀನಿ ಮಧ್ಯಾಹ್ನದ ಕ್ಲಾಸು. ಈಗಾಗಲೇ ಈ ಬ್ರೇಕಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ತಿಂದಿರ್ತೀರಾ ಅಲ್ಲ. ಇವಾಗ ಇನ್ನೊಂದಷ್ಟು ನಿದ್ದೆ ಬರ್ಬೋದು. ಹಾಗಾಗಿ ಕಥೆ ರೂಪದಲ್ಲಿ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತೀನಿ ಯಾವ್ಯಾವ ತರ ಈ ಜೆಂಡರ್ ಜಸ್ಟಿಸ್ನ ಅಡ್ವೊಕೇಟ್ ಮಾಡ್ತಾ ಬಂದ್ರು ಅಂತ. ಒನ್ ಇಂಪಾರ್ಟೆಂಟ್ ಕೇಸ್ ಇಸ್ ಮಧುಕರ್ ನಾರಾಯಣ್ ಮೆರ್ಡಿಕರ್ ಅಂತ ಒಂದು ಪ್ರಕರಣ 1991 ಅಲ್ಲಿ ಡಿಸೈಡೆಡ್ ಬೈ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ತುಂಬಾ ಚೆನ್ನಾಗಿ ಇದೆ ಕೇಸ್. ಏನಂದ್ರೆ ದೇರ್ ವಾಸ್ ಎ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಇನ್ ಬಾಂಬೆ, ಇನ್ ಒನ್ ಆಫ್ ದ ಏರಿಯಾಸ್ ಇನ್ ಬಾಂಬೆ. Under his jurisdiction, there was a slum. There was a slum. In that slum, there was a beautiful lady. He used to go around, frequently have chat with that lady. He tried to ravish that lady. He tried to have sexual favor from that particular lady. And in one fine day, in that particular slum in afternoon, where majority of the people would go for work, and only less number of people are there at home in slum areas. He went to that area, tried to ravish that lady. That lady raised hue and cry. ಹೋದ ಮಧ್ಯಾಹ್ನ ಟೈಮು ಆಕೆ ಜೊತೆ ಬಲವಂತ ಮಾಡೋಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ದ. ಆಕೆ ಕಿರ್ಚ್ಕೊಂಡು ಜನ ಸೇರಿದ್ರು. Then that police officer again what he did, he made a call to his junior officers, and then he asked the additional police force to bring in law and order there. And that police officer, what he did was, he arranged a scene that, and he filed an FIR against that lady, stating that she was indulging in selling of some illicit liquor. ಒಂದು ಫಾಲ್ಸ್ ಕೇಸ್ ಹಾಕ್ಬಿಟ್ಟ ಅವಳ ಮೇಲೆ. ಈಕೆ ಕಳ್ಬಟ್ಟಿ ಮಾರ್ತಾ ಇದ್ಲು, ಹಿಡಿಯೋಕ್ ಹೋಗಿದ್ದೆ, ಅವಾಗ ಕಿರ್ಚ್ಕೊಂಡು ನೋಡಿದ್ರೆ ನನ್ನ ಜೊತೆ ಲೈಂಗಿಕ ಸಂಪರ್ಕ ಒಂದು ಪ್ರಯತ್ನ ಮಾಡ್ದ ಅಂತ ಹೇಳಿ ನನ್ನ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾಳೆ ಅಂತ ಒಂದು ಕೇಸ್ ಹಾಕ್ದ. ಬಟ್ ದಿ ವಾಲಂಟರಿ ಆರ್ಗನೈಸೇಷನ್, ಫೆಮಿನಿಸ್ಟ್ ಆರ್ಗನೈಸೇಷನ್, ದೇ ರೈಸ್ ದೇರ್ ವಾಯ್ಸ್, ಅಂಡ್ ಅಟ್ ಲಾಸ್ಟ್ DYSP ವಾಸ್ ಅಪಾಯಿಂಟೆಡ್ ಟು look into the matter. He submitted a report, and in that report he made clear that police officer was at fault. ಪೊಲೀಸ್ ಆಫೀಸರ್ ತಪ್ಪು ಮಾಡಿರೋದು ನಿಜ ಅಂತೇಳಿ ಅವರು ರಿಪೋರ್ಟ್ ಕೊಟ್ಟರು. ದೆನ್ he was suspended. After suspending him, there was an FIR filed against him. The lower court convicted him. The lower court convicted him for outraging the modesty of a woman and attempt to commit rape. ಅದಕ್ಕೆ ಅವನಿಗೆ ಶಿಕ್ಷೆ ಆಯ್ತು. ಯಾರಿಗೆ? ಪೊಲೀಸ್ ಆಫೀಸರ್ಗೆ. ಎಲ್ಲಿ? ಕೆಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಂತ ಕರಿತೀವಿ ಅಲ್ಲಿ. He filed an appeal before the Bombay High Court. ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಡೆಯುತ್ತೆ. ಎಷ್ಟು ಚೆನ್ನಾಗಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿ ನೀವೆಲ್ಲ. ಮತ್ತೆ ಈ ತರ ಕೇಸ್ ಲಾಸ್ ಎಲ್ಲ ಕೇಳ್ತಾ ಇದ್ರೆ ನಾಳೆ ನೀವೆಲ್ಲರೂ ನಿಮ್ ಕೆಲಸ ಬಿಟ್ಬಿಟ್ಟು ಲಾ ಕಾಲೇಜಿಗೆ ಜಾಯ್ನ್ ಆಗ್ಬಿಡ್ತೀರಿ ಅಥವಾ ಲಾ ಓದೋಕೆ ಶುರು ಮಾಡ್ಬಿಡ್ತೀರಿ. ಅಷ್ಟು ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಆಗಿರ್ತವೆ ಲಾನಲ್ಲಿ ಯಾವಾಗಲೂ. ಇಲ್ಲೇನಾಯ್ತು, that was a wonderful argument by a defense counsel on behalf of this police officer in Bombay High Court. ಆರ್ಗ್ಯೂ ಮಾಡುವಾಗ ಏನ್ ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ ಅಂತಂದ್ರೆ, ಇನ್ ದ ಲೋವರ್ ಕೋರ್ಟ್ ಸಾಮಾನ್ಯವಾಗಿ ಹೆಣ್ಮಕ್ಳ ಕೇಸ್ ಹಾಕಿದ್ರೆ, ರೇಪ್ ಕೇಸ್ ಆದ್ರೆ, ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಕೇಸ್ ಆದ್ರೆ, ದಿ ಅಪೋನೆಂಟ್ ಪಾರ್ಟಿ ಟ್ರೈ ಟು ಅಸಾಸಿನೇಟ್ ದರ್ ಕ್ಯಾರೆಕ್ಟರ್. ಹೆಣ್ಮಕ್ಳನ್ನ ನೀವು ಸೋಲಿಸ್ಬೇಕು ಯಾವ್ದಾರ ಕೇಸಲ್ಲಿ ಇದ್ರೆ ಕ್ಯಾರೆಕ್ಟರ್ ಬಗ್ಗೆ ಮಾತಾಡ್ಬಿಟ್ರೆ, ಕ್ಯಾರೆಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಂತ ಕೊಡ್ತಾರಲ್ಲ, ಅಲ್ಲಿ ಇದ್ ಮಾಡು. ಅಲ್ಲಿ ಕೆಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಏನಾಗಿರ್ತದೆ, ಪಾರ್ಟಿ ಸವಾಲ್ನಲ್ಲಿ ಈಕೆ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಳ್ಳುವಂಗೆ ಮಾಡ್ಬಿಟ್ಟಿರ್ತಾನೆ ಲಾಯರು. ಏನಾಗಿರ್ತದೆ ಇಷ್ಟೇ, ಶಿ ಅಡ್ಮಿಟೆಡ್ ಇನ್ ದ ಲೋವರ್ ಕೋರ್ಟ್ ಆನ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ವೈಲ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನಿಂಗ್ ದಟ್ ಶಿ ಹ್ಯಾಸ್ an affair with somebody, that is extra marital relationship. ಆಕೆಗೆ ಬೇರೆಯವ್ರ ಜೊತೆ ವಿವಾಹೇತರ ಸಂಬಂಧ ಇದೆ ಅಂತ ಒಪ್ಕೊಬಿಟ್ಟಿರ್ತಾಳೆ ಆಕೆ. ಅದನ್ನೇ ಇಟ್ಕೊಂಡು ಇನ್ ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ ದೇ ಆರ್ಗ್ಯೂಡ್ ದಟ್ ಶಿ herself admitted that she has an extra marital relationship with somebody, and she is a woman of easy virtue. I'm sorry, I have taken this word from the court file. ಕೋರ್ಟ್ ಫೈಲ್ ಇಂದನೇ ವರ್ಡ್. ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇದೆ, ಶಿ ಇಸ್ ಎ ವುಮನ್ ಆಫ್ ಈಸಿ ವರ್ಚ್ಯೂ, ಅವರ್ ಟೆಸ್ಟಿಮನಿ ಕೆನಾಟ್ ಬಿ ರಿಲೈಡ್. ಆಕೆ ಕ್ಯಾರೆಕ್ಟರ್ ಸರಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಆಕೆಯ ಹೇಳಿಕೆ ಆಧಾರದ ಮೇಲೆ ಒಬ್ಬ ಆನೆಸ್ಟ್ ಪೊಲೀಸ್ ಆಫೀಸರ್ಗೆ ನೀವು ಶಿಕ್ಷೆ ಕೊಡೋದು ಸರಿನಾ ಅಂತ ಆರ್ಗ್ಯುಮೆಂಟ್. ದೆನ್ ಬಾಂಬೆ ಹೈಕೋರ್ಟ್ ಸೆಡ್ ಕರೆಕ್ಟ್, ಶಿ ಇಸ್ ಎ ವುಮನ್ ಆಫ್ ಈಸಿ ವರ್ಚ್ಯೂ, ಅವರ್ ಟೆಸ್ಟಿಮನಿ ಕೆನಾಟ್ ಬಿ ರಿಲೈಡ್ ಅಪಾನ್. ಆಕೆ ಹೇಳಿಕೆನ ಆಧಾರದ ಮೇಲೆ ಒಬ್ಬ ಪೊಲೀಸ್ ಆಫೀಸರ್ಗೆ ಶಿಕ್ಷೆ ಕೊಟ್ಟಿರೋ ತಪ್ಪು ಅಂತ ಅವನ್ನ ಖುಲಾಸೆ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಅವನ ಮಗ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಗಿದ್ದು ನೇರವಾಗಿ DYSP ಆಗ್ಬಿಟ್ಟು ಇನ್ನೇನು SP ಪ್ರಮೋಷನ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. against which the Bombay state government filed an appeal before Supreme Court. In that case, the Supreme Court reversed the judgment of Bombay High Court and held that even though she is a woman of easy virtue, she is entitled to have a right to privacy. ಆಕೆ ನಿಮ್ಮ ಪ್ರಕಾರ ಈಸಿ ವರ್ಚ್ಯೂ, ಎ ವುಮನ್ ಆಫ್ ಈಸಿ ವರ್ಚ್ಯೂ ಇರ್ಬೋದು, ಆದ್ರೆ ಅವಳಿಗೂ ಒಂದು ಪ್ರೈವೇಸಿ ಅಂತ ಇರುತ್ತೆ. No one can compel her, force her. You are having, affair with somebody. Why not with me? Isn't it? It is absurd. It is inhuman. It is cruel. Correct? Then the court held that even though she is a woman of easy virtue, she is entitled to enjoy a right to privacy. That in that case, while deciding such case, the Supreme Court analyzed the sensitivity of the matter. How sensitive the matter is. A woman is always placed in a disadvantageous position in a society. If judiciary become a party to make her life further miserable, it is an injustice done to women for that large. That is the opinion of the Supreme Court in this case. Then comes, in another case, the Punjab and Haryana High Court held that subjecting a woman for virginity test amounts to violation of her right to privacy. Virginity test ಅಂತ ಕರೀತೀವಿ. ಅಂದ್ರೆ ಏನಂತಂದ್ರೆ ಇಷ್ಟೇ, ಗಂಡ ಹೆಂಡತಿ ಇಬ್ರು ಚೆನ್ನಾಗೇ ಇರ್ತಾರೆ, ಚೆನ್ನಾಗಿರುವಾಗ ಚಿನ್ನ ರನ್ನ ಅನ್ಕೊಂಡು ಚೆನ್ನಾಗಿರ್ತಾರೆ. ಆಮೇಲೆ ಏನಾದ್ರೂ ಅವಳು ಎಂಥದ್ದು ಈ ಮ್ಯಾಟ್ರಿಮೋನಿಯಲ್ ಕೇಸು ಇವೆಲ್ಲ ಏನಾರ ಹಾಕಿ ನನಗೆ ಎಂಥದ್ದು ಜೀವನಾಂಶ ಕೊಡ್ಬೇಕು ಅದು ಇದು ಅಂತ ಬಂದಾಗ, ಆವಾಗ ಅವಳ ಕ್ಯಾರೆಕ್ಟರ್ ಸರಿ ಇಲ್ಲ, ಬೇರೆ ಇದಿತ್ತು ಅಂತ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತಾರಲ್ಲ, ಆಗ ಅದಕ್ಕೆ ಏನು ಅದನ್ನ ಕಂಡುಹಿಡಿಯೋದು ಹೇಗೆ? ದೇರ್ ಆರ್ ಸಮ್ ಟೆಸ್ಟ್, ಡಬಲ್ ಫಿಗರ್ ಟೆಸ್ಟ್ ಇಸ್ ದೇರ್ ಅಂಡ್ ದೆನ್ ವರ್ಜಿನಿಟಿ ಟೆಸ್ಟ್ ಇಸ್ ದೇರ್. Then the experts can conduct the test, and in that test, if it is proved that yes, she is having some affair with somebody else, then it is the court will consider that there will be no maintenance for you. You go. They will grant divorce based on the ground of adultery. But here in this case, the court held that for chota mota reason, you cannot put a woman for virginity test. It is violative of her dignity and right to privacy. This is an important case under section 120 of CRPC, that is maintenance provision. Another important case, a milestone decision by the Supreme Court in the year 1985 is, this case is popularly known as air hostess case. ಗಗನ ಸಖಿಯರ ಪ್ರಕರಣ ಅಂತ ಕರೀತೀವಿ. ಇದರಲ್ಲಿ ಏನು, ನರ್ಗೇಸ್ ಮಿರ್ಜಾ, ಏರ್ ಇಂಡಿಯಾ ವರ್ಸಸ್ ನರ್ಗೇಸ್ ಮಿರ್ಜಾ ಕೇಸ್. ಈ ಕೇಸಲ್ಲಿ ದಿಸ್ ಏರ್ ಹಾಸ್ಟೆಸ್ ಕ್ವಶನ್ ದ ಏರ್ ಇಂಡಿಯಾ ಅಂಡ್ ಇಂಡಿಯನ್ ಏರ್ಲೈನ್ಸ್ ರೆಗ್ಯುಲೇಷನ್. ವಾಟ್ ರೆಗ್ಯುಲೇಷನ್ ವುಡ್ ಸೇ ಇಸ್ ದಿಸ್? ದ ಕಂಡೀಷನ್ ಇಸ್ ದಿಸ್: an air hostess would retire from service upon attaining the age of 35 years. ನಿಮ್ ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಎಷ್ಟು ಮೇಡಮ್? ಈಗ ಯಾರಾದ್ರೂ ಹೇಳಿ ನೋಡೋಣ, ಆನ್ ಮಾಡಿ. ಹೆಣ್ಮಕ್ಳು, ನಿಮ್ ರಿಟೈರ್ಮೆಂಟ್ ಏಜ್ ಎಷ್ಟು? 60 ಅಲ್ವಾ? ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ಓಕೆ, 60. ಆದ್ರೆ ಏರ್ ಹಾಸ್ಟೆಸ್ 62 ಈಗ ಗೊತ್ತಿಲ್ಲ ನನಗೆ, ಇನ್ನೂ ಆಗಿಲ್ಲ. ಪ್ರಪೋಸಲ್ ಇದೆ. ಯೂನಿವರ್ಸಿಟಿ ಆದ್ರೆ 62. ಕರೆಕ್ಟ್, 62. ಇನ್ನು ಬೇರೆ ಇಲ್ಲಿ ಕಾಲೇಜಿಯೇಟ್ ಎಜುಕೇಶನ್ ಬರ್ತಕ್ಕಂಥವಾದ್ರೆ 60 years. ಓಕೆ, ಇಲ್ಲಿ an air hostess would retire from service upon attaining the age of 35 years. Number one, first condition. Second one, she will be terminated from service if she marries within 4 years from the date of joining. ಆಕೆ ಕೆಲ್ಸಕ್ಕೆ ಸೇರಿದ 4 ವರ್ಷದೊಳಗೆ ಮದುವೆ ಆದ್ರೆ she will be sent out. She will be terminated. ಎರಡನೇದು. Third important condition is that an air hostess will lose her job during her first pregnancy. ಆಕೆ ಮೊದಲನೇ ಪ್ರೆಗ್ನೆನ್ಸಿನಲ್ಲಿ ಆಕೆನ ಕೆಲಸದಿಂದ ತೆಗೆದುಹಾಕಬಹುದು. These are all the things she questioned it before the court of law. But what Supreme Court here held that 35 years is okay. It may be even 40 years, 50 years, because at the time of joining, you only knew that your retirement age is 35. ಅಲ್ವಾ? ನೀವು 35 ವರ್ಷಕ್ಕೆ ರಿಟೈರ್ ಆಗ್ಬೇಕು ಅಂತ ನಿಮ್ಗೆ ಸರ್ವಿಸ್ ಕಂಡೀಷನ್ ಇದ್ದು ನೋಡ್ಕೊಂಡೇ ತಾನೇ ಅಲ್ಲಮ್ಮ ನೀವು ಜಾಯ್ನ್ ಆಗಿರೋದು. ಮತ್ತೆ ಏರ್ ಅಷ್ಟೇಸ್ ಜಾಯ್ನ್ ಆಗೋದು ಎಷ್ಟು ವರ್ಷಕ್ಕೆ? 18ರಿಂದ 20 ವರ್ಷಕ್ಕೆ ಜಾಯ್ನ್ ಆಗ್ತಾರಾ? ಈವನ್ ಅಟ್ ದ ಯಂಗ್ ಏಜ್ ಯು ಜಾಯ್ನ್. ಹಾಗಾಗಿ ಓಕೆ. ಅಂಡ್ ದೇ ಕನ್ಸಿಡರ್ ಇಟ್ ಇಸ್ ಆಲ್ಸೋ ಅನ್ರೀಸನಬಲ್. ಅದು ಸೆಕೆಂಡರಿ. Then Supreme Court took strong exception that terminating her during her pregnancy is violative of her right to privacy and violative of Article 21 of the Constitution. Why? Because pregnancy, yes, ಹೇಳಿ sir. Dr. Shama, tell me. Yes, I can't get you. Please. Hello? Dr. Shama? Please raise your hand if you have, if you want to say anything. Okay, right. Come back to our discussion here. The Supreme Court held that the termination on the first pregnancy within 35 years and in service held unreasonable and liable to be struck down because the pregnancy is a natural course in a life of a woman. Then that pregnancy cannot be considered as an impediment. That cannot be considered as an impediment. That means you can make use of her service, if not as air hostess, you can use her service as a ground staff. Alva? Again, it will have its own impact. A pregnant woman always frequently traveling in the air, her BP will also fluctuate, and child's, the security is also, its health is also important for us, we agree. Instead of terminating her service, what you can do? You can use her service as a ground staff, isn't it? Then the Supreme Court struck down these provisions as unconstitutional. In another case relating to LIC, Life Insurance Corporation of India, in Neera versus Life Insurance Corporation of India, decided in 1992. In that case, Supreme Court perused the matter. It is violative of right to privacy of a woman because a woman, before taking her, life insurance policy, she has to specifically answer to some question and she has to fill some details. The details are, which are personal in nature, which are embarrassing, which are humiliating and violating of her privacy, like, have you aborted prior to this date? Or have you, what is your menstruation cycle, whether it is regular, or do you face any abnormality in it, and etc. etc. Such are the questions asked to a woman before taking, before her life is being insured with the Life Insurance Corporation of India. Then the Supreme Court struck down that provision and held that it is humiliating to a woman and violative of gender equality. You remove all such things. If at all, if you want, you refer her to the medical examination. Any medical examination is compulsory, medical test is compulsory for everybody. Then she has to be sent to the designated health officer. Then the health officer certificate is sufficient in that respect, but you cannot force her to have, force her to disclose all such details. Very important case is Vishaka versus State of Rajasthan. It is very important because you are going to join, you already joined service, and then in your organization also, internal complainant committee is there, ICC is there, correct? Then ICC, because of this case, in the year 1997, Vishaka, a voluntary organization, has approached the Supreme Court. They have conducted a study. Their project was this: what is the condition of a working woman at workplace? Is she safe at workplace or not? Or in case, if there is no unfavorable situation for a woman, how can she independently work and discharge her duty properly? You remember, A woman is subjected to sexual exploitation at workplace, sexual harassment at workplace. I'm sorry to use sexual exploitation, sexual harassment at workplace, even sometimes by her superior officer, sometimes by her colleague, sometimes by her junior, sometimes by the public, general public. Then in such circumstances, how to create a atmosphere, conducive atmosphere for her to work? They brought it to the notice of the Supreme Court that in case of sexual harassment, there is only one provision in the Indian Penal Code to punish the culprit. That is Section 354 of the Indian Penal Code, previous code, that is outraging the modesty of a woman. For which, what is the punishment? 1 month is the punishment, 1 month to 6 months is the punishment, and 1,000 rupees is the penalty. Then added to that, you see, the responsibility to prove sexual harassment is on the complainant, not on the part of the person against whom allegations are made or accused in this case. ಯಾರಪ್ಪ ನನ್ನ ಮೇಲೆ ಸೆಕ್ಸುವಲ್ ಹರಾಸ್ಮೆಂಟ್ ಮಾಡೋಕ್ ಬಂದಿದ್ದ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋ ಹೆಣ್ಮಗಳೇ ಪ್ರೂವ್ ಮಾಡಬೇಕು, ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂಫ್ ಅದರಲ್ಲಿ. ಹಾಗಾಗಿ ಇವರು ಇದನ್ನೆಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ತಂದಾಗ ವಾಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ದಟ್ ನಿಮ್ಗೆ ಇಟ್ ಈಸ್ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ, ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ, ಒಂದು ಎಕ್ಸಾಂಪಲ್ ಕೊಡ್ತೀನಿ ನಿಮ್ಗೆ. ಪಂಜಾಬ್ ಅಲ್ಲಿ ಒಬ್ರು ಪೊಲೀಸ್ ಆಫೀಸರ್ ಇದ್ರು, ಗಿಲ್ ಅಂತ ಹೇಳಿ, ಸೀನಿಯರ್ ಪೊಲೀಸ್ ಆಫೀಸರ್. He was a tough cop, one who is responsible for eradicating Khalistani movement in Punjab. Antha strict officer ivaru. Avaru senior IPS officer in a party, in an inebriated condition perhaps, he touched inappropriately body of a senior IAS officer, namely Rupen Bajaj. Our interview ಎಲ್ಲ ಪತ್ರಿಕೆಲ್ಲ ಬಂದಿತ್ತು. ರೂಪೇನ್ ಬಜಾಜ್ ಅಂತ ಒಬ್ರು IPS ಆಫೀಸರ್ನ ಒಂದು ಪಾರ್ಟಿನಲ್ಲಿ, ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿನಲ್ಲಿ ಎಲ್ಲೋ ಮುಟ್ಟಿದ್ರು ಅಂತ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ದಟ್ ಅಮೌಂಟ್ಸ್ ಟು ಏನದು outraging the modesty of a woman. She filed a complaint. Nobody is ready to take a complaint. No police officer is ready to register police complaint against their own boss. ಕೊನೆಗೆ she went to court under CRPC 200, that is private complaint. Under private complaint provision, the court ordered for registration of FIR. Then FIR has been filed against him, charge sheet has been filed against him. He was convicted by the lower court, but the matter went before High Court, went before Supreme Court. Supreme Court taken into consideration his greatest service to the nation. They slapped 2.5 lakh as fine and acquitted him from the charges. ಯಾರ ಕತೆ ಇದು? ಒಬ್ರು ಸೀನಿಯರ್ IAS ಆಫೀಸರು ರೂಪಾ ಬಜೇರವರೇ ಕೇಸ್ ನಡೆಸಿ, ಅಷ್ಟೆಲ್ಲ ಬಲ ಇದ್ಕೊಂಡು, ಅಧಿಕಾರ ಬಲ ಇದ್ದು, ದುಡ್ಡಿದ್ದು, ಇಂಥವ್ರ ಕೇಸ್ ನಡೆಸಿ ಕೇಸ್ ಗೆಲ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವಾಟ್ ಅಬೌಟ್ ದ ಕಂಡೀಷನ್ ಆಫ್ ಎ ಪೂರ್ ವರ್ಕಿಂಗ್ ವುಮನ್ ಇನ್ ಎ ಗಾರ್ಮೆಂಟ್ ಫ್ಯಾಕ್ಟರಿ? Then who is responsible in case of any sexual harassment to a working woman at workplace? Then Supreme Court, in this case, in the year 1996, they passed a judicial order. They made rules, exercised their power under Article 142 of the Constitution. ನೀವು ಸಂವಿಧಾನ ಓದುವಾಗ 2 ಆರ್ಟಿಕಲ್ ನ ಮರೀದೆ ಜುಡಿಷಿಯಲ್ ಪವರ್ ಸಂಬಂಧಪಟ್ಟಂತೆ ಓದಬೇಕು. ಸೆಕ್ಷನ್ ಆರ್ಟಿಕಲ್ 141 and 142. Article 141, whatever the decision given by the Supreme Court becomes law of the land. ಯಾಕೆ ಅಂದ್ರೆ because it is the highest court of the land. It becomes a law. 142, in case of extraordinary, this is extraordinary jurisdiction of the Supreme Court to do complete justice. To ensure complete justice, the court can make laws, to make rules and regulations. Here in this case, the Supreme Court framed its own rules. The Working Woman Protection from Sexual Harassment Rules 1996. ಮಾಡಿದ್ರು ಅವ್ರು. ಅದನ್ನ ರೂಲ್ ಮಾಡಿ ಏನ್ ಮಾಡಿದ್ರು ಗೊತ್ತಾ ಅವರು? ಈ ಕಾನೂನು ಮಾಡುವಾಗ ಹೇಳ್ತಾರಲ್ಲ, ಹೂ ಇಸ್ ಎ ವರ್ಕಿಂಗ್ ವುಮನ್, ವಾಟ್ ಈಸ್ ವರ್ಕ್ ಪ್ಲೇಸ್, ದೆನ್ ಇದು ವಾಟ್ ಅಮೌಂಟ್ಸ್ ಟು ಸೆಕ್ಸುವಲ್ ಹರಾಸ್ಮೆಂಟ್, ಅದನ್ನೆಲ್ಲ ಬರೆದ್ರು ಅದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು. ದೇ ಫ್ರೇಮ್ಡ್ ದೇರ್ ಓನ್ ರೂಲ್ಸ್. ದೆನ್ ದಟ್ ರೂಲ್, normally it is not the job of a judiciary. Judiciary has to, what it has to do? Judiciary has to administer justice, resolve the dispute, it cannot make laws. The making law is the prerogative of the legislature. ಯಾರು ಕಾನೂನು ಮಾಡೋದು ಸಂಸತ್ತಿನ ಸಾರ್ವಭೌಮ ಅಧಿಕಾರ, ಅದು ಶಾಸಕಾಂಗದ ಸಾರ್ವಭೌಮ ಅಧಿಕಾರ. ಅದನ್ನ ಇವ್ರು ಮಾಡುವಂಗಿಲ್ಲ, ಕೋರ್ಟ್ ಅವ್ರು ಮಾಡುವಂಗಿಲ್ಲ. ಬಟ್ ದೇ ಡಿಡ್ ಇಟ್ ಹಿಯರ್ ಇನ್ ದಿಸ್ ಕೇಸ್, ಎಕ್ಸರ್ಸೈಸಿಂಗ್ ಪವರ್ ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 142. ಇಲ್ಲಿ ಮೊನ್ನೆ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಒಂದು ಕೇಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಯ್ತು, ಜ್ಞಾಪಕ ಇರ್ಬೇಕು ನಿಮ್ಗೆ. ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಎಕ್ಸರ್ಸೈಸ್ ಇಸ್ ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಪವರ್ ಅಂಡರ್ ಆರ್ಟಿಕಲ್ 142. What allegation there was this? Bangalore Bar Association election is going to be held, wherein there was no representation to women. No representation to women. All office bearers are only gentlemen will, because the minimum number of ladies are there, lady advocates are there in the bar. Then their appeal is this before the Supreme Court: you reserve treasurer post for women and implement 33% reservation for women in advocate association election. Supreme Court said yes. Supreme Court created, Supreme Court held, yes, the treasurer post should reserved for women only, and there must be 33% reservation for women in the bar association election. You see, that is exercising power. These are all the attempt made by the judiciary to ensure gender justice and gender equality, because men dominated bar it is. Bar association we call, it is not our bar and restaurant. It is bar means advocates association is called as a bar. In bar association, it is a men dominated profession it is, where how to ensure representation to women. Supreme Court exercises power under article 142 and reserved post, treasurer post for women. Then it is the case where in Vishaka case also, the Supreme Court issued a guidelines and framed rules, and Supreme Court held that in this case, this rule will be enforced till it is replaced by regular legislation passed by the Parliament. But Parliament from 1996 to 2013, they have taken their own sweet time. In 2013, Supreme Court passed a legislation replacing these rules. Supreme Court ಈಗ ನಮ್ಮ ಪಾರ್ಲಿಮೆಂಟ್ ಇವಾಗ ಒಂದು ಕಾನೂನು ಮಾಡಿದ್ದಾರೆ. ಆ ಕಾನೂನು ಇದೆ, ಅದ್ರ ಪ್ರಕಾರ ಏನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ದು ಅದೇ, ಈಗಿರೋದು ಅದೇ. ಇನ್ ಕೇಸ್ ಆಫ್ ಎನಿ ಕಂಪ್ಲೇಂಟ್ ಬೈ ಎ ವುಮನ್ ಎಂಪ್ಲಾಯಿ ರಿಗಾರ್ಡಿಂಗ್ ಸೆಕ್ಷುವಲ್ ಹರಾಸ್ಮೆಂಟ್, it is the responsibility of the head of the institution or head of the organization to constitute a committee that refer the matter to a committee. That committee must be a permanent committee, internal complaints committee. That committee necessarily be headed by a woman. Then other two women members must be there. I mean, who has to inquire such matter? The matter has to be inquired by the internal complaints committee headed by senior woman officer of that organization or any other organization, and one representative from general public, lady representative, preferably from NGOs. You need to take an outsider also in that. And in case if the head of the institution failure on his part to refer the matter to the internal complaints committee, ಈಗ ನಾನೇ ಪ್ರಿನ್ಸಿಪಲ್, ಇಫ್ ದೇರ್ ಆರ್ ಎನಿ ಕಂಪ್ಲೇಂಟ್ ಇಯರ್ ಅಂತಂದ್ರೆ ಐ ಹ್ಯಾವ್ ಟು ರೆಫರ್ ದ ಮ್ಯಾಟರ್ ಟು ದ ಕಮಿಟಿ. ಫೇಲ್ಯೂರ್ ಆನ್ ಮೈ ಪಾರ್ಟ್ ಟು ರೆಫರ್ ದ ಮ್ಯಾಟರ್ ಟು ಕಮಿಟಿ, ದ ಲಾ ವಿಲ್ ಪ್ರಿಸ್ಯೂಮ್ ದಟ್ ಐ ಓನ್ಲಿ ಕಮಿಟೆಡ್ ಸೆಕ್ಷುವಲ್ ಹರಾಸ್ಮೆಂಟ್. ನಾನೇ ತಪ್ಪು ಮಾಡಿದ್ದೀನಿ ಅಂತ, ಅಲ್ಲಿಗೆ ಪನಿಷ್ಮೆಂಟು ನನಗೆ, ಅಂದ್ರೆ ಅಷ್ಟು ಹಾರ್ಶ್ ಆಗಿದೆ ಇದು. ದಟ್ಸ್ ವೈ ಯು ಸಿ ಹೌ the attempt made by the judiciary to interpret laws, even to make rules and regulations to protect the dignity of women. These are all the cases. And then I would like to bring it to your notice an important case decided by the Supreme Court in 2017. This is popularly known as triple talaq case. That is in Mohammedan practice it is, where a person, a man can divorce his wife pronouncing thrice talaq in front of minimum 2 witnesses. Then here in this case, this lady approached the Supreme Court, and many other petitions have been also clubbed. This is Shahra Bano versus Union of India, decided in 2017. Supreme Court held that this is inhuman and it is unconstitutional. Supreme Court perused several religious books and the scripts regarding this talaq, and they are of the opinion that this Anafi, I think it is Anafi practice or something it is called, that practice is no longer valid, and the pronouncing this type of triple talaq is violative of Article 14, 19, and 21 of the Constitution, since there is no religious protection under Muslim law in the opinion of the Supreme Court. There are many other case laws and the provisions relating to guaranteeing a woman right to equality and to bring gender justice. And we are talking something about man and woman. Then what about third gender? In Nas Foundation case, there was a argument before the Supreme Court that even third gender is also considered as a separate gender, and they have to be given the right to recognize their own gender. Take, for example, transgender means a person, one who born as a man, may converted himself undergoing some physical operation or something, and then he can turn himself as a female, and or vice versa. And some people are there, they are exclusively, lesbians, homos, and other bisexuals, and etc. In different names they are called. And the popular name for them is Ijras. ಅಥವಾ ಬೇರೆ ಬೇರೆ ಹೆಸರುಗಳಿಂದ ಕರಿತೀವಲ್ಲ ಅದು. What about their identity? In National Legal Services Authority versus Union of India case, this was decided in 2014. In that case, the Supreme Court held that third gender also should be considered equally on that of man and woman. And they have every right to identify themselves with a particular gender. A woman, one who converted herself or become a man, then she can identify herself as a man. Or this man, I had a problem here in my institution where one transgender had taken admission here. And he joined as a Shivkumar, and by the time he passed out, he changed his gender and changed his name as Shivani. And he always used to demand me here, when he comes here, he demand that I must call him as Shivani, not Shivkumar. Then I used to tell him, no, Pa, you have to approach appropriate bodies in that respect. You get an order. Then after getting that particular order and certificate, I can request the university to change your gender and your name. And we have done it accordingly. That is the different thing. But anyhow, these type of changes are also there, where even gender, the word gender is also includes LGBTQ, a separate gender, that is, otherwise we call it as third gender. Okay. Next, let us go to some of the other areas. Rape is considered certainly an heinous crime. And this rapist is not only violate the victim's right to privacy, but also cause a serious psychological and physical harm to a woman. That's why we had Section 375 and 376 under Indian Penal Code. And also very important, one more important provision to ensure gender justice and gender equality and protect women folk was Section 304B of the Indian Penal Code, which is popularly known as dowry death. ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, dowry death ಅಂತಂದ್ರೆ there is a presumption. Not all the deaths are considered as dowry deaths. ಅಲ್ಲಿ ಇದ್ದಿದ್ದು ಪ್ರಾವಿಷನ್ ಇಷ್ಟೇ. If a married woman dies in unnatural way within 7 years from the date of marriage, the court shall presume it is a dowry death. ನೋಡಿ ಎಷ್ಟು harsh ಆಗಿತ್ತು ಪ್ರಾವಿಷನ್ ಅಂದ್ರೆ, if a married woman dies unnaturally or meets unnatural death within 7 years from the date of her marriage, then the court shall and law shall presume that it is a dowry death. And contrary is on the others, husband and in-laws, to prove that they are not indulging in dowry case and etc. That was the thing. It is still there, but it is in a different form. It is not so wild now. Earlier, yeah, in case any unnatural death, the police used to apprehend or arrest the husband, in-laws, father-in-law, mother-in-law, sister-in-law, and other in-laws. They used to arrest. But now, after Supreme Court decision, as soon as the FIR is being filed, the police officer has to investigate the matter. In case if a prima facie is of the opinion that others are involved in that, then he can make arrest. Otherwise, he cannot. The same thing happened even in case of Section 498A, which is considered as cruelty against married women. 498A ಕಂಪ್ಲೇಂಟ್ IPC ಮೇಲೆ ಕೊಟ್ಟರು ಅಂದ್ರೆ ಮುಗೀತು ಕತೆ. ಗಂಡ, ಅತ್ತೆ, ಸೊಸೆ, ಇದು ಅತ್ತೆ, ಮಾವ, ನಾದ್ನಿಯರ್ ಎಲ್ಲರೂ ಜೈಲಿಗೆ ತಕೊಂಡು ಹೋಗ್ಬಿಡುವರು ಮೊದಲು. ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೂಲಿಂಗ್ ಏನಿದೆ ಅಂತಂದ್ರೆ, ಫಸ್ಟ್ ದ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಹ್ಯಾಸ್ ಟು ಕಂಡಕ್ಟ್ ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ. In the preliminary inquiry, prima facie is of the opinion that there is, torture to that woman or harassment to that woman for dowry purpose or any other cruelty is meted out to her. Cruelty is of both, that is mental as well as physical cruelty. ಆ ಥರದ ಕ್ರೂಯಲ್ಟಿ ಇದೆ ಅಂತ ಅನ್ಸಿದ್ರೆ ಮಾತ್ರ ಅರೆಸ್ಟ್ ಮಾಡಬೇಕು. ಇಲ್ಲ ಅಂತಂದ್ರೆ ಸುಮ್ಮನೆ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಬಿಸಾಕ್ಬಿಟ್ರೆ ಸಾಕು. ಎಷ್ಟೋ ಜನ ಸೊಸೆಯಂದ್ರು ಎದುರಿಸೋರು. ಈ ಕೆಲವು ಕಾನೂನುಗಳ ಕತೆ ಹೇಗಾಗ್ಬಿಟ್ಟಿದೆ ಅಂತಂದ್ರೆ, ನೀವು ಕಾಲೇಜಲ್ಲಿ ನೀವು ಮುಂದೆ ನೋಡ್ತೀರಾ, ನೀವು ಕೆಲವು ಪ್ರಿನ್ಸಿಪಾಲ್ಗಳಿಗೆ ಈಗ ಟೀಚರ್ಸ್ಗೆ, ಲೇಡಿ ಟೀಚರ್ಸ್ಗೆ ಏನಾದ್ರು ಕೆಲಸ ಹೇಳೋದೋ ಬೈಯೋದೋ ಕಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದೆ. ಈಗ ಏನಾರ ಹೇಳಿದ್ರೆ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಬರ್ದು ಬಿಸಾಕ್ತೀನಿ ಅಂದ್ರೆ ಕತೆ ಏನಾಗ್ಬೇಕು? ಕಲೀಗ್ಸ್ ಕತೆ ತಾನೇ. ಅದರಲ್ಲೂ ಬೇರೆ ನೀವೆಲ್ಲ ನ್ಯಾಕ್ ಮಾಡ್ಬೇಕು ಅಲ್ಲ, ನ್ಯಾಕ್ ಕೆಲಸ ಇವೆಲ್ಲ ಏನಾದ್ರು ಬಂತು ಅಂದ್ರೆ ನಮ್ಗೆ ಪ್ರಿನ್ಸಿಪಾಲ್ಗಳಿಗೆ ಎಂಥ ತಲೆನೋವು, ಟೆನ್ಷನ್ ಅಂದ್ರೆ ಈ ಹೆಣ್ಮಕ್ಳ ಹತ್ರ ಕೆಲಸ ಮಾಡೋದೇ ಕಷ್ಟ ಆಗ್ಬಿಟ್ಟಿದೆ. ಇಲ್ಲ ಸರ್, ನಾನು ಮನೆಗೆ ಹೋಗ್ಬೇಕು, ನಾನು ಇಷ್ಟೊತ್ತಿಗೆ ಹೋಗ್ಬೇಕು, ಇದು ಮಾಡ್ಬೇಕು. ಬಟ್ ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ದಿಸ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ. ವೆನ್ ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ದಿಸ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ, ಇಟ್ ಈಸ್ ಆಲ್ಸೋ ಇಟ್ ಈಸ್ ಆಲ್ಸೋ ನಾಟ್ only a profession, it is also an opportunity for you to serve your institution, isn't it? Then you have to do all types of work assigned by the institution like NAC or any other statutory authorities like AICTE, Bar Council of India, and other organizations are there. But anyhow, come back to our discussion. Yeah, this section 497, it is also, we have already discussed, which deals with adultery, and 498A, that is harassment and other things. There are many such legislations are there, which are in fact, violate the right to equality concept of woman. And then there is a law to protect such women. I have taken only few important areas to impress upon you how laws are there to ensure gender equality and gender justice. This is about my submission, and I would like to discuss one more important area. That case I have omitted. Even though it is a religious prescription, our Supreme Court declared it is violative of the right to equality clause. That is Indian Young Lawyers Association versus State of Kerala decided in 2019. That is this is popularly known as Ayyappa Swami temple case, where a woman of certain age are prohibited from entering to go to pilgrimage, the sancto sanctorum of Lord Ayyappa. ಬಹುಶಃ ಪ್ಯೂಬರ್ಟಿ ಏಜ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಹೆಣ್ಮಕ್ಳು ಹೋಗ್ಬಾರ್ದು ಅಂತ ಅಲ್ಲೇನೋ ಒಂದಿದೆ. ಬಿಕಾಸ್ ಈಸ್ ಎ ನೈಸ್ತಿಕ ಪರಂಪರೆ, ದಟ್ ಇಸ್ ದ ಗಾಡ್. He may not, it is the age-old practice that a woman is not supposed to enter of that particular group of age. Then the Supreme Court, when it was questioned before the Supreme Court declared that it is violative of constitutional morality. The word used by the Supreme Court is constitutional morality. Then what constitutional morality demands is this. Constitution is not only a political document. It is not only a legal document. It's a document on humanity. It is a document on everything. It is a sacred document. Then that cannot be violated. That spirit cannot be violated. Then in this case, the court is of the opinion that it is certainly violative of the constitutional morality. However, Dr. Indira Banerjee, Justice Indira Banerjee, in this case, being a woman, she gave dissenting judgment. In her opinion, that is the essential religious practice. A woman of that age should not be allowed to enter the temple. ನೋಡಿ, ಇಲ್ಲಿ ಗಂಡು ಮಕ್ಕಳು ಹೆಣ್ಮಕ್ಳು ಪರವಾಗಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರು. ಆದ್ರೆ ಆ ಬೆಂಚಲ್ಲಿ ಇದ್ದು ಒಬ್ಳು ಹೆಣ್ಮಕ್ಳೇ ಹೇಳ್ತಾರೆ, ಅಲ್ಲಿ ಹೆಣ್ಮಕ್ಳನ್ನ, ಈ ವಯಸ್ಸಿನ ಹೆಣ್ಮಕ್ಳನ್ನ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗೋಕೆ ಬಿಡಬಾರ್ದು, ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಇಟ್ಸ್ ಎಸೆನ್ಷಿಯಲ್ ರಿಲಿಜಿಯಸ್ ಪ್ಲೇಸ್. ಏನಾದ್ರೂ ಇರಲಿ, ದಟ್ ಮೆಜಾರಿಟಿ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಿವೈಲ್ಸ್ ಓವರ್ minority judgment. But anyhow, here in these are all the cases which ensures, and many other legislations are also there. Take for example, in case of Dowry Prohibition Act and then Domestic Violence Act, their intention is to uplift the position of a woman and to treat her on par with men. But the most of the provisions, I think in the last class, Mr. Ponnanna or somebody, he raised a question that, sir, these are all the laws which are, misused and abused by the people. I gave him the answer that, can you show me any one of the legislation which is not being abused or misused? Then most of the legislations have been used, misused, and abused. And we have to encourage people, those who use this legislation for the benefit of their own self and also for the benefit of others. Friends, I extend my sincere thanks to University of Mysore, MMTTC, and then its director and coordinator, and all my brother and sister colleagues, those who have been working in various organizations as lecturers, for providing me this opportunity and for your patient hearing. Before going to the question and answer session, I think we have only few minutes time to conclude our discussion. Now this discussion is open for discussion. This lecture is open for discussion. You can raise any question or you can supplement anything. Even you can criticize me also, if at all, if you want.
Hello, sir. So this was really a very
Yes.
enriching session, very informative it was.
Yes.
My question is about what is the marital rape, which was actually in discussion and it was
Very
also
good.
before the court. And
Very
can you just throw some light on?
Very. Thank you. Om Prakash, no? Om Prakash has asked this question. I
Yes,
think
yes.
somebody. No?
Yes, sir.
Shakin
Prakash,
Raj.
yes.
Yes, okay. It's a very good question. In some of the Western countries, they consider non-consensual intercourse itself is a crime, whether it is between husband and wife, because in some countries, there is no concept called adultery. Take, for example, if you go to France and other countries, most of the European countries, the word, adultery is unheard of. They used to say consensual intercourse and non-consensual intercourse. That's all. That is the difference. But here in India, in the marital rapes are reported. Most of the marital rapes are reported. It's a type of cruelty on women as per some of the feminist organizations. But the argument on behalf of the Union of India is this. When the matter went before the Supreme Court, still it is pending before the Supreme Court. Supreme Court issued notice to Union of India and sought its response. Union of India, that is the present day government, they filed an affidavit opposing criminalizing marital rape. Because why? In India, the marriages are survived on makeup rather than breakup. In Western countries, always what happens, if you do not like, you break away, you go. Correct? That is the concept. But in India, we always adjust to one thing, that ego adjust ಮಾಡ್ಕೊಂಡು ಹೋಗಿ, isn't it? ಸುಮಾರು ಜನ ಸಂಸಾರ, ಯಾಕೆಂತಾರೆ ಎಲ್ರು ನಾವು ನೀವೆಲ್ರೂ ಬಹುಶಃ ಮದುವೆ ಆಗಿರೋರು ಹೆಚ್ಚಿನ ಜನ ಇಲ್ಲಿ ಇದ್ರೆ, ನಾವು ಒಂದ್ಸಲ ನಮಗೆ ನಾವು ಪ್ರಶ್ನೆ ಹಾಕೊಂಡ್ರೆ ಎಷ್ಟು ಜನ ನಾವು ನಮ್ ಕಾನ್ಶಿಯಸ್ ವಿರುದ್ಧವಾಗಿ ಎಷ್ಟೋ ಸಂದರ್ಭಗಳಲ್ಲಿ ನಡೀತಾ ಇರ್ತೀವಿ ಮ್ಯಾರಿಟಲ್ ಇದ್ರಲ್ಲೇನೆ. ಇದೇ ನಿಜ. ಆದ್ರೂ ಏನೋ ಒಂದು ಆಯ್ತು ಅಂತ ನಾವು ಬ್ರೇಕಪ್ ಆಗಿ ಹೊಟ್ಟೋಗಿಲ್ಲ ನಾವು, ಅಲ್ವಾ? ಹಾಗೆ ಹೇಗೋ ಮೇಕಪ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದೀವಿ, ಇದು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ ಕಾನ್ಸೆಪ್ಟ್ ಅಲ್ಲಿ ಇದೀವಿ. ಬಟ್ ಎನಿಯೋ, ಫಾರ್ ಯುವರ್ ಕ್ವಶನ್ ಇಸ್ ದಿಸ್: ದ ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಈಸ್ ನಾಟ್ ಇನ್ ಫೇವರ್ ಆಫ್ ಇಟ್, ಬಿಕಾಸ್ under Hindu custom, the marriage is a sacrament, it is not a contract. But whereas in other religion, marriage is a contract, including Mohammedan law, the marriage is a contract, it is not a sacrament. But in Hindu, marriage is a sacrament because marriage is a sacred institution. For a flimsy grounds, it cannot happen. But the scale of the what we call the harassment or the crime committed against the woman, number one, and in the name of live-in relationship, in the name of artificial insemination, in the name of some other new concepts are there, no? They are all threatening the whole sacredity of whole institution of marriage. Then we are already, the marriage institution is under stress. If you are an educated man, and howsoever, your education qualification increases means your tolerant level is decreasing. When it comes to marital relationship, I am talking. If you allow marital, this marital intercourse or the marital rape as one of the crime, then I hope so, the whole marriage institution will be breakdown. It will break down. Okay. Then it is better, we need to consult the many, relevant organizations in this respect, take their opinion, and the time will tell you, and if not today, certainly in another 10 to 15 years or 20 years, the marital rape will be considered in India also as an offense. But time is not ripe at this stage. To my opinion, this is my opinion. Yes, sir. Any other question?